Right then, we've all got one in our neighborhood, haven't we? That house on the corner, the one with the slightly worrying cracks and a roof that's seen far better days. Ever stop and wonder what actually stops it from becoming a real, proper danger? Well, let's dive in.
You know the scene. A leaning garden wall, a bit of a dodgy-looking roof, and you can't help but wonder, whose job is it to step in before disaster strikes? Well, here in the UK, that responsibility often lands squarely on the shoulders of your local council. And trust me, they've got some pretty serious legal powers up their sleeves to deal with it.
But hang on. Before a council can start throwing its weight around and taping things off, they have to be able to prove that a structure is legally, officially dangerous. And you know what? That's actually a bit trickier than it sounds.
Here's a funny thing. The main bit of law they use, the Building Act, doesn't actually give a definition for the word dangerous. Nope, not a sausage. So what do the courts and councils do? They literally turn to the dictionary. In practice, though, it boils down to this. Any building or structure that a qualified officer looks at and says, yep, that's unsafe and it's a risk to people's health and safety.
And you can see from past legal cases just how broad this can get. It's not just the obvious stuff, like one house in a terrace collapsing and threatening the whole row. It can be something much more subtle, like someone removing a fire escape. The building itself might look fine, but suddenly its whole condition becomes dangerous.
So once a structure has that official dangerous label slapped on it, what can the council actually do about it? Well, let's have a look inside their legal toolkit.
Pretty much everything comes down to two key sections of the Building Act. I want you to think of them as two completely different paths the council can go down. And the choice between them? Well, it all hinges on one simple question. How much time have they got?
So let's look at the first path. This is the standard procedure. It's called Section 77. This is the methodical, court-ordered approach for buildings that are definitely dangerous but aren't, about to fall down in the next 5 minutes.
This is the formal, by-the-book route. The council identifies the problem, they get all their evidence together, and they present their case to a court. The court then issues a legally binding order to the owner. Now, if the owner just decides to ignore it, not only are they committing an offense, but the council can then step in, do the work themselves, and send the owner the bill.
And the real clout here, the real power, is that it carries the weight of a court. It's not just the council's opinion anymore, it's a judge's ruling. And that gives the council a really solid legal footing and makes it incredibly difficult for a property owner to argue with.
But what happens when you just don't have time for the courts? What if a wall is literally crumbling onto a public pavement right now? Well, that is where the emergency powers come in.
This is the council's big red emergency button. Section 78 is designed for those heart-and-mouth situations where public safety is at immediate, imminent risk. It basically lets the council bypass the courts and take direct action right away to make the situation safe. So there you have it. That's the crucial difference. Section 77 is your slow, steady, legally sound route, all backed by a judge. Section 78 is the break glass in case of emergency option. One gives you legal certainty, the other gives you pure, unadulterated speed. And for the council, that's a massive trade-off to consider. But this emergency power, well, it's a bit of a double-edged sword for the council. Acting fast might just mean fencing an area off to keep people safe. But if they get that call wrong, if a court later on looks at it and decides the danger wasn't truly imminent, the council could find itself on the hook for paying out compensation to the property owner. So the stakes are high. And all this brings us to a really vital question. Who actually gets to make these massive, high-stakes decisions? I mean, deciding to take emergency action on someone's private property, that requires a very specific legal authority.
These critical judgments are made by trained professionals inside the council. We're talking about your building control officers or your environmental health officers. They're the ones who have the delegated authority to use these hefty powers. Honestly, the entire process rests on their expertise.
And you can think of their required skills as a bit like a three-legged stool. First, an officer has to know the law, inside and out. Second, they need the practical, on-the-ground skills to properly inspect a dodgy structure and gather evidence. And third, and this is crucial, they've got to be able to accurately assess the real level of risk. If any one of those legs is wobbly, the whole thing can come crashing down.
So let's pull all of this together. What does this whole legal framework really mean for keeping us, the public, safe?
At its heart, the Building Act of 1984 gives councils a really balanced and adaptable set of tools. The choice between that deliberate, court-ordered approach with Section 77 and the immediate emergency action of Section 78 means they can have a proportionate response, one that's tailored to the specific level of risk they're facing.
But ultimately, these laws were drafted 4 decades ago. They're still our frontline defense against dangerous structures. And with our buildings across the country continuing to get older, it really does raise a massive question. Are these powers, and the skilled officers who have to use them, still enough to keep us safe in the 21st century?